May it please the court. My learned friend had, I would suggest, two big points that featured heavily in his submissions. The first was that the purpose of the assumption is limited to ensuring that the tenant doesn't pay a price for the freehold that greatly exceeds the amount of money he has spent on the improvements. There has to be, my learned friend says, a degree of proportionality between the money that the tenant has shelled out on the improvements and the reduction in the price that he pays to the landlords. I want to tackle that one first, cost and value. The second big point was that the increase in value, which is at the heart of the preliminary issue, was attributable to something which Mr. Scarfe wasn't responsible for, namely a change in the planning policies of the Royal Borough of Kensington and Chelsea, which itself, as my learned friend correctly says, was a reaction to changes in the structure of the London housing market. So he says there should be a relationship between cost and value. He says Mr. Scarfe did nothing to produce the extra value. My submission, both of those points are fundamentally wrong. I deal first with cost and value. Yeah. There is no evidence about the cost of the works undertaken in the 1970s and 1980s. Not surprising, because the cost of the work is completely irrelevant to the legal issue. As to the effect on value, the figures that my learned friend has referred to, the 2.5 million and the 11 million, which he referred to as bookends, are not comparable. Cadogan has declined to say what, on its case, the property was worth on the assumption that you value it unimproved in the condition it would have been if the works had not been carried out. Indeed, Cadogan insisted on there being a preliminary issue so that it wouldn't have to say what its case was on that. So we don't know. We know what Cadogan says the freehold was worth on the assumption that although the works are undone, you can immediately do them again without getting listed building consent or planning permission. But we don't know what Cadogan says it's worth if you value it on the assumption the works were never undertaken in the first place. We have provided figures for both of those alternatives. Figures are 2.56 million for the lower figure and 4.25 million for the higher figure, which is a difference of about 40%. And that can be compared with the figures in Shalson, where the difference was about 31% between the value of the property if it was valued as a house and the value of the property if it was valued as divided into flats.
Sorry, what did you say the percentage was in this case?
In this case, on our figures, it's 40%.
40, yeah.
We don't know what it is on Cadogan's case. In Shalson, the figures that are recorded in the speech of Lord Hoffman, which derive from the decision of the Lands Tribunal, the figures were 275,000 if it was valued divided into flats, and 398,000 if it was valued on the assumption it was in its original condition before conversion into the flats as a single house. And that was a difference of £123,000 or 31% of the higher figure. My learned friend said in his submissions that the difference in Shalson was attributable to the cost of the works, but that is not the case, as I will show the court. What in fact happened in Shalson is that the tenant's valuer valued the building by reference to comparable sales of buildings divided into flats. That's how he got to his unimproved value. And the landlord's valuer, who was valuing by reference to the building as it had been when let as a single house, looked at comparable sales of properties sold as houses. The assumption that we are concerned with, that the court is concerned with, forms part of the statutory direction to ascertain the amount which the freeholder's interest would sell in the market on the valuation date, subject to the lease and subject to the assumptions. But it's in the context of a market sale. An improvement is, as my learned friend has said, a physical thing. So a set of works that are done to a property to change it in some respect. Works that are not mere repairs or renewals, the House of Lords said in Shalson. But we are concerned with the impact on value of changes to the property. and an improvement has no value separate to the reaction of the market to the improvement. Very expensive works, which the tenant thinks are wonderful. And so, from the tenant's point of view, our improvements may add nothing to the value of the house. They may reduce the value. A tenant who lines his living room with black marble and expensive mirrors at vast expense may find that buyers knock something off the price to allow for the cost of removing the improvements. Top developers who have a big reputation in the market, at the top end of the market, can get vast amounts more than they pay for buildings, vastly in excess of the amount they pay to buy the property and spend on it, because of their reputation with the very richest people who want something beautiful that they can move into and that they know has been done to a very high standard. The way in which improvements affect value is always dependent on factors which are outside the control of the landlord and tenant, factors that have no relationship between the landlord and tenant. And there is nothing in the statute to limit the factors that can influence value. In particular, there is no direction that any influence on value of planning, listed building and building control, legislations, policies or practices are to be disregarded. My learned friend says that his interpretation is one open on the language of the statute, but it isn't. My learned friend has to go much further than interpreting the words used. He has to read words in that are not there. He has to read in a disregard of any effect on value caused by changes in planning policies, listed building legislation and policies, building regulations. Indeed, the whole regulatory framework which affects the ability to carry out changes to real property. The value of an improved property compared to an unimproved property will depend on a variety of things, and I'm not proposing a comprehensive list, but here are some things which I suggest will very often influence the effect that an improvement has on value. The first is supply and demand. This is illustrated by the Shalson case, which we will be looking at shortly. But in Shalson, works were carried out to convert a house into flats, and at the time that would have increased the value, but then changes in the housing market meant that the demand for houses exceeded the demand for flats, and that meant the improvements lost their value and indeed reduced the value by the valuation date by about 31%. A beautiful Victorian conservatory may add value because of the demand for original architectural features of that kind and the scarcity of properties that have those features, whereas an ugly modern one may reduce the value of property. The second thing that can influence the impact that improvements have on value is changes in the cost of carrying out works due to the availability and cost of building contractors and building materials. If it gets much harder to find builders and their prices go up a lot and the cost of building materials go up a lot, then all other things being equal, the value of existing improvements will increase, not because of anything the landlord has done or the tenant has done, but because of external factors. A third thing that can affect value is a change in the information available to the market. There was a time when a lot of buildings were overclad with material to try and improve their thermal insulation. And at the time, no doubt, everybody would have thought that expenditure resulted in an increase in the value of the buildings. But then it later turned out that the cladding materials used were flammable and dangerous, and then they reduced the value of the building. That was a factor that had nothing to do with anything the owner of the building or the leaseholders of the building had done. It was a purely external factor, but it had a dramatic effect on the impact that the alterations had had on the value of the building. If I can pick up a point made by my Lord Justice Newey, matters such as fashion and taste can influence value. And taking up my Lord's example, if the individual who we know as Banksy had a house and painted murals on the inside and outside of it at a time when they were relatively unknown, it would probably reduce the value of the property. if they then became very famous indeed, it would probably vastly increase the value of the property. And finally, the factor that we are concerned with here, regulatory factors. There are a host of regulations which change over the years, which govern what you can do to a building and how you can do it. And as time goes on, they change. Planning policies change. This building was listed in the 1980s. That was an external change. Building regulations change regularly as new information comes to light, and of course there's an ever-increasing emphasis on energy efficiency and insulation. And that may well have an impact on the value of improvements, which may increase them or decrease them in terms of the impact they have on the value of the property.
Well, I can think of, and there is perhaps another example, I don't know how that bears at all on the argument. For example, policies relating to basements, of which there are some in the development plan for Royal Borough. They got tighter.
Yes.
And therefore those properties which had the benefit of the rather more relaxed policy regime may command a higher pro rata value because they happen to have been undertaken before the change in policy on basements. I don't know, is that an example that would
Yes,
go to
that is another very good example. That if you were able to create your basement cinema room, and in one case I did a vast underground parking complex for vintage cars before the change in policy, then you have a set of improvements that will increase in value when it becomes impossible to do that with other properties.
Yeah.
But if you have a property with a very elegant Victorian conservatory and you assume it's not there, you can't simply assume you can replace it, because if you wanted to build a conservatory today, you'd have to comply with the current building regulations and have particular types of glass in the window and a limited amount of glass to prevent solar gain, and so on. And all these different factors operate in the real world. They mean that the value of works done to change a building change over time, and none of these changes have anything to do with the landlord or the tenant. And it can't be right to impute to Parliament an intention to exclude some particular factors that affect value from those factors to be taken into account. After all, the statute envisages that the valuation, if it can't be agreed, will be determined in the first instance by the first-tier tribunal in England and the Leasehold Valuation Tribunal in Wales, and on appeal to the upper tribunal, to expert tribunals. And in my submission, what Section 91A(d) does is leave the question of the impact that improvements have on value, and the impact it would have if the improvements had not been made, the expertise of the tribunal, without limiting any particular factors which can be taken into account as having an influence on value. My learned friend's case is, in effect, that only those changes in value which are directly attributable to the amount of money that the tenant has spent on the improvements can be taken into account. And as I have already said, that does not involve interpreting the assumption, it involves interpolating words into it. Well, the other big point that my learned friend had was that the increase in value hadn't been caused by the works, but the increase in value was caused by the works. And there are two related points here. The first is that when Mr. Scarfe carried out the works, focusing here on the internal alterations carried out in the 1970s, the carrying out of those works itself brought about a change in the use of the property from 5 flats to a single house. And the local planning authority then had 4 years in which to serve an enforcement notice under Section 87, subsection 3 of the Town and Country Planning Act 1971, if they considered that the change of use was a material change of use and one that ought not to be permitted. As my Lord, or Justice Lindblom knows far better than I do, these questions are ones for the discretion of the planning authority. they have to take a view on whether something is a breach of planning control, and if so, whether it's right to use public money to stop it.
Whether it's expedient.
Yes. Section 87.3 is in the bundle, tab 2, page 65, but perhaps it's unnecessary to turn it up.
The relevant period is 4 years.
Yes.
The period for works, however, was longer.
Yes.
10
years.
10 years.
10 years for works, 4 years for change of use to a single dwelling, 10 years
10
for
years.
all other.
Yeah. So if it was a dwelling, it was 4 years.
Yes.
Use as a dwelling.
And
yeah. So again, I think we're waiting. Whether you're going to agree, I hope you are going to agree what policies we should see to illustrate the point that I think is common ground. Probably.
I'm quite sure that we can agree. We've discussed it. The case that we pleaded, and which Cadogan admitted, which then found its way into the Statement of Agreed Facts, was based on a document, and I can't now remember what it was, but it was a document in which the planning authority said, this is what we used to say, and this is what we're going to say from now on. So we just took it from that.
Yes, yes.
What we didn't do, what I haven't done, is seen the actual material that shows the planning policies in the 1970s, but my instructing solicitors are doing their best to get hold of that as we speak.
Yeah, no, that would be most helpful.
And I'm sure we can agree a document for the court and get that to the court.
I imagine, I don't remember, but I imagine that the policy in question will effectively be a, if you like, a deeming policy, a policy that indicates the likely approach of the local planning authority to a change of use proposal, which involves the loss of residential units. And that up to 4 units, or whatever it was, up to 5 units, they would generally not. Of course, it would be a matter of discretion in every case. I mean, I'm only imagining what the policy must say in order to have had that effect.
Yes,
Yeah.
well,
I don't remember. Perhaps I should remember, because I must have done cases years ago which concerned it, but I can't remember what it says.
I remember looking and then finding the document that said this is what we used to say and this is what we now say, and I thought that was probably enough, but I should clearly have gone further, and we will go further and go back to what the position was.
Yeah, well, I mean, you're going to agree this, isn't it?
Yes. But for present purposes, really regardless of what the policy was, what the attitude was of the local planning authority, as a matter of law, the carrying out of the works for the purpose of turning 5 flats into a house clearly were works that brought about a change of use. And as a matter of law, that started a 4-year enforcement period running. And if I could ask the court to look at tab 19 in volume 2 of the authorities briefly. Sorry, tab volume 1.
Sorry, tab.
Tab 19.
I think that's the
Case called Impey, Secretary of State.
Impey.
Yes. And the relevant page, looking at the page numbering at the bottom, is 307. And if I could ask the court to read the very last paragraph on page 307 and the first paragraph on the next page, please.
Question of fact and degree.
Yes, but it's not necessary in order for there to be a change of use to residential development for the property to be lived in. If you convert 5 flats into a house and then you put it on the market to let, you find that some time before anybody moves in, the 4-year period starts to run when the works are completed, probably when they're usable. And that decision has been approved by the Supreme Court. In another case, it's in the bundle, but I don't think it's necessary to turn up, but for the court's note, it's called Welwyn Hatfield Borough Council and the Secretary of State, which is in tab 35. So, when Mr. Scarfe carried out his works, the internal alterations, it had the effect as a matter of law of giving the planning authority a 4-year period in which to serve an enforcement notice. Once that period had passed, by carrying out the works, Mr. Scarfe had achieved a situation in which it was impossible for the planning authority to require the property to be reconverted into flats. It was his works that achieved that. So the
sorry to interrupt you. Were the authority aware at the time of the works being undertaken or not?
My lord, I don't know.
No, I mean it's possible that they were. We're not in the territory of works being undertaken in any way. I'll use the expression improperly, by some sort of subterfuge. We've had some egregious examples of that in cases, the haystack cases and so forth.
Yes, that is the Welwyn case.
That's Welwyn, of course it is, yes.
Yes, and I believe that there's now a specific provision in the 1990 Act covering concealed changes.
I mean, that was an extraordinary case, as I remember the facts, in which the landowner had physically disguised the dwelling that he had created. I think probably from a barn, I don't know whether it was or not.
That's right.
By erecting a haystack around it, which
I think the haystack case may be a different one.
There was a haystack.
There is a haystack.
There was a haystack.
Yes.
A barn.
Fiddler.
Fiddler, yes.
The fiddler.
Yeah.
Building completed building which had the external appearance of a hay barn.
That's right.
The Welwyn case, what the builder did is he built something that looked exactly like a agricultural barn with from the outside, but inside it was a house. And then at the end of the 4 years, the barn sides just sort of fell away, and there was a house.
And the revelation of the dwelling house.
The drum roll, no doubt.
Yes, but
I mean, extraordinary fact. I mean, one could struggle to invent them, I think.
Indeed.
Anyway, we're not in anywhere near that territory.
No, I mean, it's an agreed fact that in the 1970s, the attitude of the planning authority was this sort of thing was fine. So, Mr. Scarfe wasn't doing anything wrong.
No, not at all.
But what he was doing was adding to the value of the property by giving it by his works produced a planning status, which meant that after the end of 4 years from the carrying out of the works, regardless of whether the property was used or not used or left empty or anything of that kind. So that's the first point. And the second point is that the works enabled, which is agreed, as my learned friend correctly said, enabled the property to be used as a house, and then it was used as a house. And our submission is that when building works enable a property to be used in a way, and it is used in that way, so as to add value by reason of that use, if you are going to ensure that the price is diminished by the amount by which the value has been increased by the improvements, you have to take out both the improvements and the use enabled by the use. You take the third floor. Until 1987, it was a flat roof at the back of the third floor. And Mr. Scarfe then, at his own expense, built an artist studio there. And after that, he drew cartoons in the studio. But if you're going to disregard, take out of the evaluation the work that he did to create the studio, you must also take out of the equation the fact that he thereafter used the studio to draw cartoons in. He couldn't and wouldn't have drawn cartoons on the flat roof. You don't have to assume any particular use of the flat roof. You just assume that the works weren't done and the use enabled by the works weren't done. If a tenant builds a granny flat extension, then one values the house without the extension and without the granny. you value on the assumption that the granny didn't live in the extension because it was the construction of the extension that enabled her to live there. The works and the use go together and can't be separated. My learned friend said more than once in his submissions that it's my case that one must assume that the building was used as flats between the 1970s and 2019. That is not my case at all. It's quite unnecessary to make any assumption of any kind about the use of the property. What one is valuing is the landlord's interest in a building at a particular date, the 13th of May 2019, in order to give effect to the assumption in 91AD. You value on the assumption that the works that were in fact carried out had not been carried out. You make no other assumption of any kind. You don't need to. It's quite unnecessary. To do that would be adding what's been Mr. Justice Scott in the Cardgrange case called adding hypothesis on hypothesis. That was a casino rent review case where the actual property had been used in the period up to the valuation date by Crockford's as a casino, and Mr. Justice Scott held that the effect of the rent review assumptions was it must be assumed to have been not used. But he said it was impermissible to go on and then say, well, if Crockford's had vacated the property, they would have set up somewhere else. He said that would be adding hypothesis on hypothesis. And you're not allowed to do that. You take the counterfactual assumption to its proper limits, but no further. It's quite unnecessary to say how the building would have been used or to pay any attention to use at all. One point that my learned friend didn't address in his submissions, but I want to draw attention to, is that Cadogan's case requires making counterfactual assumptions about both planning and listed building consents. It is an agreed fact, if we can just look at the statement of agreed facts in the supplemental bundle, tab 5. Page 27 starts. Page 28, paragraph 7. It's an agreed fact that the building was listed in 1984. As a result, since then it's been unlawful for any person to execute or cause to be executed any works of the alteration or extension in any manner of the building, which would affect its character as a building of special architectural historic interest, unless the works are authorised by a listed building consent. And paragraph 8 records that in 1987, planning permission and listed building consent were granted for the construction of the third floor studio, and each had, at condition 2, a provision that the works had to be begun within 5 years. Now, our case is that you value the property on the assumption that the internal alterations were not made and the studio was not built, with the result that if you wanted to do those works at the valuation date, you would need to get the appropriate consents. The Cadogan says you must value on the assumption that you don't need any consents.
So just to be clear, if the valuation date were the 2nd of June 1990, you would value on the basis that you had planning permission.
Well, one values on the basis that the planning permissions exist. On the 13th of May 2019, if you've got a report from your solicitor or your planning consultant, they would have said in 1987 these consents were granted. So that is a fact which has nothing to do with the works, and that must be taken into account. And it may be important or it may be unimportant. That depends on the assessment.
On the facts.
It may be very important.
I mean, you may have had a planning permission granted which was not implemented within the 5 years, in which case it would have lapsed.
Yes.
Because the time condition wasn't complied with.
And our submission is that on the 13th of May 2019, if you're looking at the third floor, one would say, well, here's a flat roof. 22 years ago, planning permission and listed building consent were granted to build a studio there. That may make it more likely that we will get a fresh consent now. But what you don't do is say, well, that is an implemented permission, because that would be to take into account the effect on value of the works that Mr. Scarfe carried out at his own expense. But Cadogan says you assume you can recreate the third floor studio without planning permission, without listed building consent. You can do the internal alterations without planning permission and without listed building consent. this is a completely unreal valuation hypothesis that Cadogan is contending for. It's something that could never exist in the real world. A property which is not divided up but is listed, where you can do the work of dividing it up without troubling yourself to get listed building consent. If I can next address the language and the context of section 91AD. If we can go back to Authorities Volume 1 and tab 1. Tab 1A is a few points on the context of section 91AD. So first of all, section 9.1, that was in the 1967 Act when it was enacted. My learned friend says it doesn't apply to many houses. Well, it doesn't apply to many houses in Chelsea, that's true. It does apply to millions of houses up and down the country. There's a decision of the European Court of Human Rights called James in the United Kingdom, where it was recorded that the evidence was that 98% of all houses, all leasehold houses in the country, would fall within section 9.1. The higher value houses, and particularly those, of course, in prime central London, were brought in later, first of all in 1974, and then finally all of them in 1993. But the original valuation assumption was incredibly pro-tenant. Without going into the details, it essentially produced the result that the tenant paid the value of the land on which the house stood, but not the value of the house itself, which was indeed the intention of the Labour government that introduced the 1967 Act. They said in the white paper that preceded it that their view was that the house belonged to the tenant and the land belonged to the landlord. Section 9.1a was introduced in 1974, and it was less favourable to tenants, but it still included two very pro-tenant assumptions. One is the one we're concerned with, and it's a one-sided assumption. If the tenant carries out works to the property and they reduce its value, well, then the tenant pays less as a result. If the tenant carries out work to the property and it increases the value, the tenant pays the same as if the works hadn't been done. So that makes it clear that that is a pro-tenant provision. And C is the other one on page 49 of the bundle, on the assumption that the tenant has no liability to carry out any repairs, maintenance or redecorations under the terms of the tenancy or Part 1 of the Landlord and Tenant Act 1954, which continues tenancies after they have expired. So our submission
meaning that if the tenant failed to comply with your repairing obligations and the property is in a dreadful state, it's valued in the dreadful state.
Yes, and also that the landlord, person who's buying the freeholder's interest, is not buying, as would be the case in the real world, on the basis that he will either get the property back in repair or get damages for dilapidations. That's the reality, but C requires a departure from reality, a one-sided pro-tenant departure from reality. And although we don't say these points are decisive, they do, we suggest, they are points that ought to colour one's reading of D and steer one in the direction of avoiding giving it a very narrow interpretation, and indeed on our submission, an interpretation which the words cannot bear. The language that's used is, one is concerned with the amount by which the value of the property has been increased by any improvement carried out by the tenant. And our submission is that Shalson makes it clear how that is to be interpreted. But even as a matter of the ordinary language of it, one would say, well, if one's trying to work out the amount by which it's increased by an improvement carried out by the tenant, the right way to do it is to assume that the improvement wasn't carried out by the tenant. That way you ensure that the value which is attributable to the carrying out of the works is removed. Next, I would like to look at what the Tribunal said on one or two points, if I may. Yes.
So we're putting the section away now.
Yes, thank you
Yeah.
very much, my lord. I'm going to the core bundle and page 29. I asked the court to look at paragraph 41. While Mr. Jordan focused on the second part of Lord Bingham's explanation in Chalson for the purpose of section 91AD, the avoidance of an adventitious gain for the landlord, Mr. Sefton stressed Lord Miller's explanation to avoid the tenant paying price which reflects a value in the property for which he's already paid. But these are opposite sides of the same coin, and no tension exists between them. And my learned friend's submission is there is only one side to the coin, which is the money that the tenant spends. But that is contrary to what Lord Bingham said, and contrary to the clear purpose of the section. If the section had been concerned, as my learned friend suggests, with the amount of money that the tenant spends, then there would undoubtedly have been a reference to the cost expended by the tenant in the section. There would have been a cap imposed saying that the reduction cannot exceed the amount that the tenant spent, and it doesn't say that. And the tribunal was therefore plainly correct to say, as was said in the next sentence, in particular, Lord Millet was not suggesting any equivalence between what the tenant had paid for the works and the degree to which the value of the house and premises may be taken to have been enhanced. I agree with Mr. Jordan that any such comparison is irrelevant, and that was, in my submission, quite plainly correct. Can we go now to Chalson? In the House of Lords, Volume 2 of the Authorities, tab 28. There are some additional points that I want to make on this that haven't emerged from the paragraphs that the court has seen so far. Can we look first at page 463, paragraph 12? This is in the speech of Lord Hoffman. May I invite the court to read paragraph 12, please?
Yes.
So the point there is that the change in value in the Chalson case was attributable to market factors, namely the change in the balance of supply and demand of houses and flats in St John's Wood, or maybe London as a whole. That is a factor which the John Lyon trustees weren't responsible for, Mr Chalson wasn't responsible for, his predecessors in title weren't responsible for it. But nonetheless, it was the key thing that influenced the impact that the works had on value. And it simply is impossible to read the statute as preventing one from taking into account changes in value, impact on value, which are attributable to some particular feature of the market. Paragraph 13 are the figures that we have seen before, that my learned friend referred to and that I've referred to, and I'll show the court in a moment where they came from. Paragraph 17 at the bottom of the page. Lord Hoffman explains that you have to identify improvements and satisfy the expert tribunal, but for those improvements the house and premises would have been worth less. And then can I ask the court please to read paragraphs 18, 19 and 20. Just a couple of points. The first is that Lord Hoffman says both in paragraph 18 and paragraph 20 that the works that were done in 1947 to convert the building into flats was an improvement for the purpose of section 91AD, and that was so even though by the valuation date the improvements no longer existed. He says in the end of paragraph 18, the Lands Tribunal was, in my opinion, quite right to say that the 1947 conversion and the subsequent reconversion were both improvements, even though the 1947 improvements had been stripped out before the valuation date, and even if they had remained intact, would have reduced rather than increased the value of the house and premises. And similarly, in paragraph 20, he says that you have to look at the hypothetical house, that's the unimproved house. You take it as having all the features of the house, including its history, except one, that the improvement in question had not been made. And then he said by that test, the 1947 improvements made no difference to the value of the valuation date because they had ceased to exist. But they are nonetheless improvements, even though they are historic and even though they no longer existed in 1997 when Mr. Shalson claimed the freehold.
Does this raise the question, or perhaps raise and answer the question, whether an improvement as such is necessarily always an increase, has an increasing effect on value rather than a diminishing one?
It raises that question and it answers it.
Yeah.
It says an improvement can reduce the value. An improvement is looked at,
as it were, a so-called improvement. I mean, I suppose
well,
it's possible. I mean, one of your improvements in your list of examples was the insertion of marble walls into a Victorian drawing room, say, and mirrors, I think you said.
that was an example based on experience of doing valuation cases, having seen what some people think is
You said black marble.
black. Yes,
With
Good.
mirrors.
I could elaborate. But
Yeah, no, there's no need.
Twinkly
at all.
lights.
Could be left to the imagination. I mean, that arguably might have had an instantly diminishing effect on the value of that property.
But it's an improvement because it makes the property better for the tenant.
Yeah. So it's I don't want to import language that I shouldn't, but it is a subjective matter, I suppose. If the tenant likes it, the tenant likes it, and that's that. It's an improvement in his eyes.
Yes.
I mean, another example which was mentioned in a different context earlier on was the insertion of a kitchen. I mean, perhaps experience teaches one that so-called beautiful kitchens inserted into expensive properties are instantly ripped out when the new occupier comes in and has a different taste and different style of kitchen wanted, and out it comes. It was only put in last year. That sort of thing. Taste is an element in this. I'm not sure you actually used the word taste, did you? But I mean, it is a
intended to say
factor.
fashion or
But I mean,
taste.
the real point is that an improvement can have a diminishing effect on value in an objective sense, even though in a subjective sense it is for the occupier of the dwelling for the time being an improvement to it.
My lord, exactly.
Just as that last point, and you said a moment ago it's an improvement from the point of view of the tenant. It doesn't have to be, does it? I mean, if a tenant does anything to a property which is not a repair or renewal, which is a physical thing, such as Lord Hoffman has in mind between B and C, then that's capable of being an improvement, isn't it? Regardless of whether it suits a tenant or not.
My lord, that is so. That is exactly what Lord Hoffman says in paragraph 18. He says it means additions or alterations to the house and premises which are not mere repairs or renewals. And later he discusses an example which the Landlords' Council had put forward of a tenant who rips out everything in the house, which does happen from time to time. There's a famous enfranchisement case about a house on the Grosvenor estate where everything had been ripped out, and the question was whether it could still reasonably be called a house. So any physical change that the tenant makes to the property, which isn't a repair or a renewal, is, as a matter of law, for the purposes of the subsection, an improvement. And it doesn't have to be something that physically survives until the valuation date. That's the point that Lord Hoffman is making in paragraph 18 and paragraph 20. And that's why he says in paragraph 20, the hypothetical house has all the features of the real house, including its history, save for one, that the improvement in question had not been made. And it is clear in our submission, as the Deputy President said, quite clear that what Lord Hoffman is saying is you do rewrite history. You do go back to the point in time when the works were done, and you value on the assumption that they had not been done when they were done. If I could next go to Lord Millet at page 469, please. These are really the same points, expressed in different language, with one additional point. May we start with paragraph 38, and if the court could read paragraph 38, please. And then paragraph 39.
Yes, right.
This is the same point that I made by reference to Lord Hoffman's speech, but perhaps comes out more clearly here. It was the change in market conditions that determined whether the works of conversion into flats added to the value or had no effect on the value or reduced the value. And you might say it's fortuitous. Depending on when the tenant serves their notice, they will get a big reduction or no reduction, or eventually get a reduction not because of section 91AD, but because the works themselves reduce the value. And then paragraph 41 next, please. I could ask the court to read that.
Thank you.
So this is the point that emerges in Lord Hoffman's speech, but it is put a little more clearly here, particularly the sentence, the second sentence, it, i.e. the improvement, any improvement, must have the effect directly or indirectly of increasing the value of the property at the valuation date, but it need not have physically survived to that date. My submission, that is completely inconsistent with Cadogan's case. Cadogan says improvements of physical things, all you have to do is assume that the physical things that were done, although they've been there all along, have disappeared just before the valuation date. That is not the approach of Lord Hoffman and Lord Millet. They say you go back in time, in this case to 1947, and you value on the assumption that the works had not been done. Now, in the case of the conversion into flats, that assumption doesn't affect the value, but it's nonetheless one you have to undertake to see if it does affect the value. And the only other point is paragraph 42.
Well, it goes on to 43, I think.
Yes, 43 as well. This is really the one-sided point that I attempted to make when we looked at section 9(1)AD. It works in the tenant's favour, but it can't work against the tenant. The landlord gets the worst of both worlds. So before leaving the Shalson case, I just wanted to make good a point I made earlier about how the figures were arrived at. We have the Lands Tribunal's decision behind tab 27. And I could ask the court to look at page 442, paragraph 9. Paragraph 9, it's agreed that the valuation date is 19th November 1997 and the freeholder will receive 50% of the marriage value. It's also agreed that if the subject property is to be valued as a house, the capital values adopted by the LVT should be accepted, namely unimproved freehold 2.25 million. And then the leasehold doesn't matter. And as to the value if divided into flats, he deals with that at page 452, paragraph 3. Paragraph 53. He says, if I'm wrong in law and the appeal property falls to be valued as if it were flats and not a house, I would accept Mr. Buchanan's valuations of 1.575 million and 1.11 million for the freehold and leasehold interests, respectively. And we see that on page 457, Mr. Buchanan's valuation. And that shows how the figure of 275,298 was arrived at. And that's the amount that Mr. Shalson ended up paying in the light of the decision of the House of Lords. If we then go on to the Fatal case, please, and volume 1 of the authorities, tab 14. This is the Fatal case, the decision of the Lands Tribunal. And if I could ask the court to turn to page 188 and to paragraph 58. paragraph 58, the member of the Lands Tribunal, Mr. Francis, said it was accepted as a fact that Mr. Buchanan, so the same valuer as had appeared for Mr. Shalson in the Shalson case, Mr. Buchanan had not undertaken for the purpose of this hearing a valuation exercise on Mr. Bryant's basis of looking at unmodernised comparables and adding to the value of improvements. He had relied upon 102 as a modernised and extended property, even though, as he acknowledged, he had not adopted this methodology in the case of 98 Hamilton Terrace, which had subsequently gone to the House of Lords. In that case, he had valued the property, which was a reconversion of 4 flats into a single house, and used as comparables only properties that were sold as flats. So with respect to my learned friend, it is not right to say that the lower figure in Shalson, the figure that Mr. Shalson actually had to pay, was arrived at by working out what the property was worth as a house and deducting the cost of turning it into a house. It wasn't arrived at that way. It was arrived at by looking at sales of properties divided into flats with whatever potential they had for conversion into a house. And if we can then go on to page 205. Paragraph 123. Mr. Francis says, in my view, the best evidence of the value that the house would have had if the improvement had not been made would come from recent sales of similar but unimproved houses in a similar location. The value could be assessed just by reference to those unimproved comparables, and if the evidence is sufficiently good, no doubt it should be. And on page 207, paragraph 131, he says the price that a purchaser will pay for an unmodernised, unimproved and unextended property will reflect what he sees as its potential for modernisation, improvement and extension, but will be no more and no less than he would have to pay for a similar property along the road. The prices that have been achieved in the vicinity for comparable properties will have included, as Mr. Buchanan admitted, development potential where any such potential existed. And in the present case, the Deputy President accepted my submission that the best evidence of the value of the property without the improvements would be a sale of property next doors, divided into 5 flats, with a flat roof on the 3rd floor, where there was a 22-year-old planning permission and a 22-year-old listed building consent which had not been implemented. That would be an exact replica of the hypothetical house. But as my learned friend is constrained to accept, such a property could not be used to give any guide to value if Cadogan is right. Nor would it be possible for any property to exist which matched the hypothetical house which Cadogan says one should imagine, namely a property where the works had been done, the property had been used as a house, and then a moment before the valuation date, the alterations had magically disappeared. And
you wouldn't expect that to be a terribly difficult valuation exercise, would you? I mean, that for which Mr. Sefton contends.
It's an unreal valuation exercise because in the real world, if you are looking at a flat roof with 22-year-old consents, you know you're going to have to get planning permission and listed building consent. I'm not saying it can't be done, it can be done, but it takes one out of the world of reality. My learned friend is very keen on reality, and rightly so. Reality principle is important. And the submission I'm making is not that the valuation could not be done, but it would be a valuation that would not be based on anything that happens in the real world. And that result is one which it is improbable to expect Parliament intended. Then can I turn to Fatal in the Court of Appeal? And starting on page 224 at paragraph 10 in the judgment of Sir Martin Norse. And he's here explaining one of the issues that the court had to decide, which is whether Section 91AD required one not only to take out of the equation value added by the improvements, but also the value attributable to the potential to make the improvements. And there are these three figures, hypothetical examples. An improved property is worth 500,000, B, the value of the unimproved property is 300,000, and C, the value of the unimproved house with the potential to improve it is 350,000. And the question was whether assumption D requires a comparison between A and B, so that the diminution is 200,000, or between A and C, so that it's 150,000. And then if we can go to paragraph 13, and if I could ask the court to read that, please. So, in our submission, what Sir Martin North says there and the way he expresses himself is entirely consistent with our case and the decision of the Deputy President, and inconsistent with Cadogan's case. Because what Sir Martin North says that one needs to do is to value the property as it would have been on the valuation date if it had not been improved, not as it would have been on the valuation date if physical things were not there. And he records the agreement that the potential for improvement would be included in the achieved sale prices of unimproved properties. We have seen that the member in the Lands Tribunal said that was the best evidence. It is the best evidence because it takes out the value of the improvements itself, but credits the landlord with whatever potential exists on the valuation date to make the improvements. And in paragraph 15, Sir Martin North says he doesn't think that Mr. and Mrs. Fatale's case is open to them on the true construction of Assumption D. That provision does not credit the tenant with the value of the relevant improvements, but only with the increase in value they have caused. That increase can only be calculated in the manner I've already stated.
No, I wasn't keeping up. Which paragraph?
I'm sorry, my lord, it's paragraph 15.
Yes, I see.
And in my submission, Cadogan is trying to essentially resurrect the argument put forward by Mr. and Mrs. Fatale and say, well, all you're concerned with is the value of the physical things that are in the building. But that's not right. The subsection is directed at the question of whether the improvements which were carried out by the tenant when they were carried out have at the valuation date the effect of increasing its value. And you can only get at that by rewriting the history so as to omit the carrying out of the improvements. I stand by my submission in relation to paragraph 18, but the court has seen that, so I won't go back to that. But I do say that what is said there is inconsistent with Cadogan's case. Paragraph 19, my learned friend has read to the court, so I'll just make one point in relation to it. The reason that the Court of Appeal rejected Mr. Driscoll's argument that the planning permissions which had been obtained by the tenant could not be taken into account appears at letter E. It being clear, see the Shalson case, that an improvement is a physical concept, I agree with Mr. Gaunt that it is the increase in value caused by the physical works which has to be subtracted. The existence or availability of planning permission is not part of those works. That tells you nothing about the situation we have in the present case, where the increase in value was caused by the works. He's not saying anything to do with planning is to be ignored when you're reading section 91AD, which is what my learned friend would like to read him as having said. And he does refer to Railstore and Playdale, but what he treats it as being authority for is the proposition that the existence of a planning permission does not have to be disregarded simply because the effect on rent but the improvements is to be disregarded. So he didn't read it in the way that my learned friend suggested it should be read. And I go next to the Sharp case, which is in volume 2 at tab 29. My learned friend took the court to this case, and he correctly explained that on the facts of this case, the improvements came after the rent review date, and therefore didn't influence the rent that was payable at the valuation date. But the decision and the reasoning applied equally to a situation where the improvements are carried out before the rent review date, and therefore the rent payable by the tenant at the valuation date is higher because of the improvements that the tenant has made. If I can begin at page 477, line 20. Mr. Radeski, who was appearing for Cadogan at that time, Mr. Radeski said if the tenant's argument is correct, considerable problems of valuation would occur where a rent review which included tenants' improvements had taken place before the valuation for enfranchisement. It would be necessary to recalculate the rent agreed to find the unimproved value. This would be a well-nigh impossible task. And then on the next page, page 478, my learned friend asked the court to read down to line 33. And what I would point out there is that the tribunal said that at every stage of the valuation, that value, i.e. the value attributable to improvements, must be excluded so that the price is thereby diminished by the value of those improvements. This exclusion must include the rent or rents under the current lease. Otherwise, full effect would not be given to paragraph D. The price would only be partly diminished by the value of the tenant's improvements. I agree with the passage from Hague, Leasehold Enfranchisement, 2nd edition, which was the last one written by Nigel Hague. The manner in which the assumption is given effect is for the property to be valued at all stages in the valuation, as if the improvements had not been made, i.e. as if the property had been in the same condition as when originally let, and it is their value, not their costs, which fall to be disregarded. That's part of his decision. And then on the next page, page 479, line 16, he says, Mr. Radeski said that the calculation of unimproved ground rents could lead to difficulties of valuation, particularly the recalculation of existing ground rent reflecting improvements, a well-nigh impossible task. He doesn't say, but that's irrelevant because this only applies where the improvements are carried out after the rent review date. He says these problems of valuation would not, in my view, present an impossible task to valuers, who, as the expert evidence given in this tribunal frequently shows, have to grapple with statutory valuation problems just as complex as this. So it's clear that he regards his decision as being equally applicable to an existing rent, which is higher because of improvements, as it is where there is a prospective rent review, which, under the terms of the lease, will reflect the value of improvements. And that is certainly how it is recorded in every edition of Hague on Leasehold Enfranchisement since the decision was published in the 1990s. If I can ask the court to look at volume 1 of the authorities, tab 5. Page 79. And it's the paragraph beginning at the top hole punch, beginning since the value.
Sorry,
Page 79, the tab 5.
Oh, I'm in the wrong tab. Yeah.
Since the value of improvements is disregarded at all stages of the calculation, this has been held to include the capitalisation of the rent, and the footnote refers to Sharpe and Cadogan. In consequence, any element of the rent payable that is referable to an improvement carried out by the tenant during the tenancy at his own expense must be disregarded. This is particularly relevant in the case of escalating ground rents that are often reviewed to a percentage of capital value or market
Would you
rent.
just pause, Mr. Gerald? Yeah. Sorry. Would you like to start again?
I was just reading, perhaps I can just ask the court to read the paragraph beginning since the value.
Yeah. Thank you very much. Yes.
So this is a practical example of the importance of the necessity of interpreting subparagraph D as requiring a rewriting of history to exclude the improvements. If you have a rent payable by the tenant, which is higher because of improvements that the tenant has made, you have to adjust that rent when valuing the landlord's interest. So that is that doesn't fit with Cadogan's suggested approach to the interpretation of the assumption, which is that you simply focus on physical things which are in the property at the valuation date and imagine that they are not physically there anymore. That's why I say that my learned friend's case is inconsistent with Sharpe and Cadogan. It is. The next topic I need to address is the reality principle. And in paragraphs 52 to 55 of our skeleton, we have set out our stall on this topic. We stand by what we say there. The reality principle needs to be considered in 3 different contexts in relation to 3 different questions that can arise. Perhaps I can open up the skeleton at a relevant paragraph. And it's in the core bundle,
Tab 11.
tab 11, and it starts at page 86, paragraph 52. So the first problem that can arise is where you simply have a direction of an open market sale or an open market letting with no particular counterfactual assumptions. And in some cases, the Lands Tribunal decided that in order to achieve a fair result, it was going to change the real world. And there are cases where the Court of Appeal, Trosset and Hoare, where the Court of Appeal said, no, if you have an open market sale, as in Trosset, which was a compulsory purchase case, or an open market letting, which is the rateable value formula in Hoare, you just value by reference to the real world. So that's the first and probably the most important aspect of the reality principle. If nothing else is said, you stick with reality. The second issue, which is the issue which arises in the present case, is what happens where there is a counterfactual assumption. And my learned friend says, in effect, you read it down. The reality principle requires you to give it as narrow a reading as possible, to stick as closely to reality as the words will possibly allow you to do. That is not the law. And I will endeavour to explain that when we look at the authorities. What we do accept is that, as Lord Justice Lewison said in Mundy, the reality principle can be relevant to a counterfactual assumption, but it comes in at the end of the process, not at the beginning. You start with all the things you always take into account when you're interpreting a statutory provision: the language, the context, the policy, the purpose. And in every case, in the bundle, that was enough to get to the interpretation of the provision. But it is at least possible that those things won't ultimately take you to a conclusion. The language may be ambiguous, the purpose may be unclear, the policy may be unclear, and you may be left with a provision that genuinely could be interpreted in two different ways. At that point, the reality principle would come in as a tiebreaker and mean that you would adopt the interpretation that is closer to reality rather than further away. The third area where the reality principle can be seen as operating is where one is considering the consequences of the assumed counterfactual state of affairs. And the court has seen the East End dwellings quotation that has appeared in many cases. You give effect to the inevitable consequences of the assumption, but you don't start inventing additional consequential, arguable, possible hypotheses on hypotheses, to use the Card-Grange formula. So that's how we submit the cases to be read. And
is it in this context that you have anything to say if you do about Kersen Park? Appreciate the context is different. Well, you've gone past. You do actually refer to Kersen Park in 54, don't you?
yes, what I propose to do now is something of a gallop through the authorities in the bundle,
Right.
which will include Kersen Park, which, in my submission, Lord Justice Lewison's judgment in that case supports what we've just said about the correct approach to the interpretation of a counterfactual assumption. What I propose to do is look at Harbinger first, then Kersen Park, which are the two most important ones, and then, as quickly as I can, go through the other authorities that we have in the bundle which concern the interpretation of valuation provisions and explain how they fit the scheme that I've shown the court.
Right.
So can I begin with the Harbinger case, in volume 1 of the authorities at tab 17. So as my learned friend has explained, this was a dispute about the amount to be paid for the shares in Northern Rock when they were compulsorily acquired, and the valuer held that the price payable was nil. That was so even though the balance sheet of Northern Rock showed a healthy positive balance, well over £1 billion. But the valuer decided that what he was required to do was assume that there'd been a fire sale of all Northern Rock's assets so that they could repay the Bank of England the money that had been made available to keep Northern Rock afloat. And that would have meant they got less for their assets than their book value, and therefore shares were worthless. And the issue turned on the interpretation of what was called the withdrawal assumption. If one looks on page 241, paragraph 2, that was the statutory provision which needed to be interpreted. In determining the amount of any compensation payable by the Treasury, it must be assumed that all financial assistance provided by the Bank of England or the Treasury to the deposit taker in question has been withdrawn, whether by the making of a demand for repayment or otherwise. And on the next page, at paragraph 6, Lord Justice Lewison explained the issue. So could I ask the court to look at that, please? And looking at page 246 and paragraphs 22 and 23, which are the ones relied on by my learned friend, in paragraph 22 he says, second sentence from the end, things are to be taken as they are in reality on the valuation date, except to the extent that the instrument postulating the hypothetical transaction requires a departure from reality. That is plainly correct. That is the essence of the reality principle. And then in paragraph 23, little Roman numeral 1, he says the hypothesis is only a mechanism for enabling one to arrive at a value of the particular property for a particular purpose. It does not entitle the valuer to depart from the real world further than the hypothesis compels. But that doesn't tell you how you work out what the hypothesis compels. It just tells you don't go further than that. Then he says the various hypotheses must be taken no further than their terms make strictly necessary. And he refers there to the Cadogan case, where in fact what Mr. Justice Scott was saying is you apply the assumptions that you're directed to apply, but you don't then start inventing all sorts of things that might possibly happen if that counterfactual state of affairs existed. Then he says it is necessary to adhere to reality, subject only to giving full effect to the hypothesis. But none of these propositions tell you how you work out what is required by the hypothesis, nor do any of the other subparagraphs. So although these general propositions are indisputable, they don't begin to answer the question, how do you work out how far from reality you are required to go by the counterfactual assumption. And page 254, paragraph 47. This is Lord Justice Lewison's conclusion in paragraph 47.
Yes.
So he thought that all that you were required to assume was that a demand had been made for repayment and not that repayment had actually occurred. He thought that anything beyond that was a consequential assumption. But the majority took a quite different view. And page 263, paragraph 84. This is the beginning of Lord Justice Mummery's judgment with which Lord Justice Beatson agreed. And Lord Justice Mummery says at the end of paragraph 84, the critical question for the court is what is the natural and ordinary meaning of the withdrawal assumption? And on page 266, at paragraph 102 and 103. Can I ask the court to read 102 and 103, please? The core of his reasoning appears on page 268 of paragraph 110.
Sorry, 100 and...
268, page 268, my lady, paragraph 110.
Thank you.
And then page 269, under the heading East End Dwellings, paragraph 115, he says the result is consistent with a long-established approach to interpreting a statutory hypothesis. Assumed payment of assistance on the valuation date may be properly described as an inevitable consequence of the hypothesis. On 22nd February 2008, all financial assistance has been withdrawn, and then he quotes Lord Asquith in East End Dwellings. And on the next page, page 270, at paragraph 118, he says the assumed consequence of repayment of loans also necessarily entails the further consequence that Northern Rock must be treated as having had to realise all its assets on the valuation date in order to make the assumed repayment of the outstanding loans on that date. So he interprets the withdrawal assumption by reference to its language and its purpose, and not starting with the expectation that he is to confine it as close to reality as possible. And what he says about the reality principle the court has seen, further down page 270, in paragraph 122. And it is a clear and unambiguous statement in my submission, and one that fits exactly with what Lord Briggs said in the Fowler case. And what
121 or 122?
122.
Yeah, 122.
My lord, sorry.
That's right.
The reality principle tells us no more about withdrawal assumption than is gathered from its wording as interpreted in accordance with established principles. The reality principle is only saying that departure from the real world must be no greater than is required by the statutory withdrawal assumption. He says the reality principle is about what is not covered by the statutory assumption. And what the passages that the court was shown by my learned friend on the interpretation of deeming provisions makes clear is you start with the ordinary process of statutory interpretation. You look at the language, you look at the policy of the statute, you look at the purpose of the provision so far as you can ascertain it. The reality principle operates outside of the assumption. And then the other case I wanted to take the court to in some detail is the Kersen Park case, which is volume 2, tab 26. My learned friend took the court to parts of this. My Lord Justice Lindblom will remember very well what the case is about, but just if I may say briefly, in case it helps. The case was about the compulsory acquisition of 4 sites in Birmingham, which were close to university campuses. And the owners of the sites each made a separate application to the upper tribunal for what's called a Certificate of Appropriate Alternative Development, a CAD, under Section 17 of the Land Compensation Act. A CAD is a certificate that if the project underlying the compulsory purchase had been cancelled and no similar project would ever take place, planning permission could reasonably have been expected to be granted for a particular development of the land. And if such a certificate is granted, then the valuation is undertaken on the assumption that a planning permission for the appropriate alternative development had been granted. So it converts a reasonable expectation of planning permission into a certainty. And the landowners each said that they had a reasonable expectation at the relevant time of the grant of planning permission for a scheme for student accommodation. And the key issue was whether in considering the applications, the tribunal could take into account the possibility of the development of the other 3 sites. So in looking at the CAD application for site 1, could the tribunal bear in mind that CAD applications have been made for sites 2, 3 and 4. And the reason this mattered is explained on page 432 of paragraph 58. Second problem is that if, as appears to be the position in this case, there was room for some permitted development consisting of student accommodation, but not as much as the cumulative total of all the CADs, how is that permitted development to be allocated in a way that is fair between the various landowners? So probably in the real world, there would have been some planning permission for some student accommodation, but very likely not planning permission for all 4 sites to have student accommodation on them. The planning authority would have been able to decide how much student accommodation was reasonably required and distribute its decision accordingly. The tribunal said that the other applications could be taken into account, but the Court of Appeal disagreed. And this was a valuation case. It was a compulsory purchase. Perhaps it's unnecessary to go through all the statutory provisions. But what does matter is the core of the reasoning, and that begins on page 429. And if I could ask the court to read paragraphs 47, 48 and 49, please. So it was a case where Lord Justice Lewison, with whom the other members of the court agreed, took a counterfactual assumption, interpreted it to produce a result that departed substantially from anything that could happen in the real world, because, as he says right at the end of paragraph 49, that is the inevitable consequence of the cancellation assumption. But that was so, whether it was unsatisfactory or not. And to see how he got there, we need to go back to page 424. So the shape of the argument, paragraph 27, the Secretary of State relied on a number of general principles, the first of which was the principle that compensation is to provide a fair financial equivalent, which is then elaborated at paragraph 29, which the court has already seen. And then Lord Justice Lewison then discusses a number of cases which, in paragraphs that the court was shown by my learned friend. And if I can then pick it up at paragraph 39, after the section that the court has already seen. Even if a legislation gives rise to surprising or even unintended results, the court is not free to depart from it by reference to a general principle such as that of equivalence. Then at paragraph 40 he refers to the reality principle, and he quotes Lord Newberger and Sparrows. Perhaps I could ask the court to read paragraphs 40 and 41. So he's saying that the presumption of reality is much the same thing as the principle of equivalence. Then at paragraph 42 he quotes his own judgment in Harbinger. And then at paragraph 43, and this is the crucial paragraph, my judgment, therefore, the starting point is the real world, modified either by an express statutory assumption or by what is necessarily inherent in the concept of an open market valuation. If there is an ambiguity in the assumption that the statute requires to be made, then the principle of equivalence may assist in resolving the ambiguity, but it is not an overriding, independent and freestanding principle. And he has said quoting Lord Neuberger, that the presumption of reality is much the same thing as the principle of equivalence. He's just referred to the reality principle, and his conclusion arrives at a result which is not consonant with reality. So in our submission, paragraph 43 is a clear statement by Lord Justice Lewison that the point in the exercise where the reality principle may have a part to play is in resolving an ambiguity, which is consistent with the way we put the position. It is not the case that you start, when looking at a counterfactual assumption, by saying the reality principle means I'm going to read this as narrowly as I can. That's not what you do. It's not what Lord Justice Lewison said you did in the Kersen case, and it would be quite inconsistent with the result that he arrived at. So now
do you happen to know, I did ask the other side, what has happened to this case? Has it got a path to the Supreme Court or not? Do you know? I simply don't know.
I haven't seen anything to suggest that it is going to the Supreme Court.
Right.
I'll see. We'll double check.
All right.
Thank
you.
So if I can then, I hope fairly quickly, go through the other cases which we have in the bundle, which concerned the reality principle, or the absence of any reference to the reality principle. The first one is the Toohey case, which is in volume 2 at tab 31. My learned friend has already shown the court this case, and the court will remember it's about a hotel in Sydney with a liquor license. And what needed to be ascertained is the unimproved value, and the court has seen the definition of that on page 443. My learned friend suggested it was compulsory purchase. He may be right. I suspect it's tax, but it doesn't really matter. The unimproved value is the capital sum which the fee simple of the land might be expected to realise if offered for sale on such reasonable terms and conditions as a bona fide seller would require, assuming that the improvements, if any, thereon or appertaining thereto, and made or acquired by the owner or his predecessor in title had not been made. And the issue was the liquor licence, because the valuation court had valued the property on the assumption that the building wasn't there, but the liquor licence was. And on page 444, Lord Dunedin.
I think it was compulsory purchase, actually. If you go back to the foot of page, internal 443.
Yes, Lord Dunedin says, it has again and again been pointed out what the value of land on compulsory purchase is.
Yes, I see.
The principle
may
here
not
is
be
exactly
that,
the same.
Yeah.
But I'm not saying my learned friend's wrong. I'm just, he may
No, I
be
mean
right.
the other context may be rating, may it?
Yeah.
Yeah.
I did try and find out what the context was. I failed, so I can't really help.
It speaks of the brevity of Privy Council decisions of their time, but it's not clear whether it's a compulsory purchase case or a rating case. But no doubt those who needed to know did.
Indeed. But if I may, at the bottom of page 494, in Lord Dunedin delivering the opinion of the Privy Council, he says, about 5 or 6 lines up, from this follows the extraordinary land, but the land is enhanced by the value of a licence which could only be granted in connection with buildings. For a licence such as this cannot be granted to sell liquor without premises, in a calculation in which you're told to assume that no building is there. There's no hint in the opinion of the Privy Council that in interpreting this provision you should start with a desire to get it as close to reality as possible and read it down in that way. What's done is to read the language and give it its natural meaning. And we do say it's a very useful parallel to Section 91AD, and the same approach is applicable to Section 91AD. The next case is the East End case, which is in Volume 1 at tab 13. The case is summarised in my learned friend's skeleton argument as terms of the statutory provisions and what the issue was. But the reason I take the court to it is for the approach that the judges took. None of them said the right way to interpret this provision was work out what reality was and then try and interpret it to produce a result consonant with reality. Most of them just looked at the language and said, that's the end of it. Lord Reed went a bit further and said, well, the language does seem to mean what the appellants say it means, but let's see how that works out in practice. But the speech which is always quoted from is that of Lord Asquith, which is on page 171. And if I could ask the court just to read the first paragraph there, please.
Yes.
And that, in my submission, was the approach of the House of Lords, to look at the language used and say, well, it's clear enough. And then the part about not boggling is at the end of that page, the last paragraph on that page. And then that's followed by a paragraph in which he says, if Parliament had intended the meaning contended for by the respondents, nothing would have been easier than to provide that the value should be assessed as if no war damage had occurred. So that case is inconsistent with the submission that the reality principle is front and centre in interpreting a counterfactual assumption. The next one is the Trosset case, which is in Volume 2 at tab 33. This was a compulsory purchase case. Trosset held a lease of a derelict cinema near Tower Bridge. The lease had about 11.5 years to run. The freeholder was the GLC, and in the past it had agreed in principle to grant Trosset a new long lease to enable the site to be redeveloped, with the potential uplift in the value to be shared between the GLC and Trosset. But then the GLC decided to build a new road crossing the site and therefore said it wouldn't grant a new lease. And Trosset then said, well, we're entitled to have the property purchased by the local authority, which was agreed, and the question was how much should be paid. And there were two issues. First, in assessing the open market value of the lease, should it be assumed, contrary to the facts, that the freeholder would be willing to grant a new lease to enable the site to be developed. And Lord Justices Magor and Lawton said no, and they applied the reality principle. Lord Justice Cairns dissented. The second point was whether Section 9 of the Land Compensation Act applied, and that's at page 541. at the bottom of page
541,
540.
did you say?
I'm sorry, my lord.
541.
541 at the bottom. No account shall be taken of any depreciation of the value of the relevant interest, which is attributable to the fact that, whether by way of designation, allocation, or other particulars contained in the current development plan or by any other means, an indication has been given that the relevant land is, or is likely to be, acquired by an authority possessing compulsory purchase powers. So that's a counterfactual assumption. In the real world, some indication of that kind has been given, but any depreciating effect on value is to be removed. And the majority, Lord Justices McGaw and Lawton, held that Section 9 did apply. At page 540, the issues are set out in the paragraph beginning, however, I think that as a result of the submissions of counsel. And at the bottom of the page, Lord Justice McGaw quotes Rule 2 in Section 5 of the Land Compensation Act. The value of the land shall be taken to be the amount which the land, if sold in the open market by a willing seller, might be expected to realise. And then over the page, he applies the reality principle to Section 5, Rule 2. And if I could ask the court to find about 5 lines down where he says the problem raised by question 1. Problem raised by question 1 arises only in such a case as the present where there's a leasehold as well as a freehold interest in the land. Rule 2 still applies. In valuing the leasehold interest, one has to assume there's a willing seller of the leasehold interest offering the interest in the open market with buyers prepared to pay a fair commercial price for it. No buyer in the open market is going to offer to pay a price which takes into account the leaseholder's share of the potential marriage value, if that buyer knows that in fact the freeholder is either unable or unwilling to do that which is necessary for him to do in order to create the marriage value. I see nothing in the legislation apart from the provisions of Section 9, which have to be considered under question 2, which compels or permits one to ignore, in assessing compensation for the leasehold interest, evidence of a fact which would be known to the buyers in the market and which would eliminate any question of marriage value. So he applies the reality principle to the straightforward open market valuation directed by Rule 2. And then at the bottom of the page he quotes Section 9.
You took us to that just now.
I'm sorry, my lord.
You've already taken us to that.
Yes, indeed. And then on page 542, at the top hole punch, opposite the top hole punch, he says, the finding of fact is that if it had not been for the Pool of London route scheme, the GLC would have been ready to negotiate and come to terms with anyone who might hold the leasehold interest on the basis of the existence of the marriage value. And then he says it's not disputed that an indication has been given that the relevant land is likely to be acquired. And then the paragraph beginning above the second hole punch, he applies Section 9 to the facts. And he says, one ought therefore, I think, to apply Section 9 on the hypothetical basis that the land, that is the claimant's leasehold interest, was at the relevant time, that is at the time of the giving of the indication, on offer in the open market with negotiations in progress. Would there have been a depreciation of the value of the relevant interest, a drop in the amount which the potential purchasers would have been prepared to offer for the leasehold interest, and would it have been attributable to the fact that the indication had been given? In my judgment, the answer to both parts of this question is yes. The phrase attributable to is, I think, deliberately used in Section 9 in order to ensure greater flexibility in its application, and would have been achieved by other phrases such as caused by. So he gave what I would submit as an expansive interpretation of Section 9. It could have been read quite narrowly because the reduction in value is in reality due to, not to the potential compulsory acquisition of the cinema, but due to the fact that the GLC were no longer willing to treat with the tenant to grant a long lease because they wanted to build a road where the cinema was. But what is certain is that Lord Justice McGaw no point mentions the reality principle as being relevant to the interpretation and application of Section 9. He does apply it to Section 5, Rule 2, but not to Section 9. And Lord Justice Lawton took exactly the same approach on page 545. The last paragraph on page 545. If I could just ask the court to read that.
At the foot of page 545.
Yes.
Yes.
So that is talking about the reality principle. You only make assumptions where either they're established by case law, like the Point-Gourd principle, or where they're required by the statute. But when he comes on to section 9 on page 547, the last paragraph of 547 is where he deals with that. So if I could ask the court to read that, please. So my submission in that case shows that the reality principle is applicable to a general direction to value in the open market. It isn't applicable, except in the case of ambiguity, to a counterfactual deeming provision like section 9. I would take the court, if time allowed, to Hoare and the National Trust, but I don't think time does allow.
Well, you can give us the references if you want. And
It's volume 1, tab 18. I'll just very briefly. It was a rating case concerning a rateable value of 2 historic houses. The Lands Tribunal said that even though both houses were loss-making, the hypothetical tenant would pay 3% of the gross receipts by way of rent, and the Court of Appeal said there was no evidence to justify that. It involved a departure from reality. But that wasn't concerned with the interpretation of a deeming provision or a counterfactual assumption. It was just concerned with the interpretation of a direction to assess rateable value by reference to an assumed letting. The Mundy case, the court has seen the sentence where Lord Justice Lewison says the reality principle is relevant or can be relevant to the interpretation of a deeming provision. He didn't go on and apply it in that case. If the court looks at that case, the court will see that there were many very powerful reasons for rejecting the arguments put forward by the appellant. And the last case is right at the end of volume 2, which is tab 36, which is Whitehall. And again, I will take this quickly in view of the limitations on. I still have the rent review cases to deal with. The issue here, as in the Mundy case, was the interpretation of the valuation provisions that apply where a leaseholder who owns a flat claims a new long lease. And the issue was whether the assumption departed from reality should be read more narrowly or more broadly. And if I can ask the court to look at page 655 at paragraph 42. First sentence of paragraph 43. It was a case in which Lord Justice Floyd said both constructions are possible as a matter of language. And what's important is that in the subsequent discussion, which goes on for many paragraphs, he considers the language, he considers the context. He doesn't at any point say, even though the Mundy case has been referred to by him, that the right approach was to start with an assumption that one should read it narrowly rather than broadly. And they do, in fact, the court did in fact read it broadly. So that again is inconsistent with my learned friend's approach. And there is not, in fact, a single authority in the bundle where a counterfactual assumption contained in a statute has been read down by reference to the reality principle rather than being interpreted by reference to the language, policy and purpose of the provision in question. So the next topic is the rent review case that my learned friend relies on, the Railstore and Playdale case. And can I begin by asking the court to go to Volume 1, Tab 9. This is an extremely well-known authority. Indeed, when I asked the Deputy President to read a paragraph from it, he said, read it or recite it.
Yeah.
So,
And how did you respond?
I said, read it, please.
Probably a percentage response, I think.
The case actually concerned a long lease of a pub, which the tenant had built, and the question of whether the hypothetical letting required under the rent review clause was to be a hypothetical letting on the terms of the real lease, restricting the use of the site to a pub, or whether it was to be such lease as could reasonably be expected to be granted in the market, which wouldn't limit it to use as a pub and would therefore produce a higher rent. And the Court of Appeal said there is a presumption of reality, which meant that the clause should be interpreted, since the clause itself didn't tell you what the terms of the hypothetical letting were. It should be interpreted as requiring that the hypothetical letting was on the same terms as the real lease. And if I could ask the court to look at page 107, letter D. And if the court could please read from letter D on page 107 to letter D on the next page.
Yes.
And there is more to the same effect, which if time allowed I would show the court. But can I ask the court to note page 108, letters H through to page 109 and to the top of page 110, which provides further emphasis to the same point. So what is being said there is that the purpose of a rent review clause is to adjust the rent to reflect changes in the real value of money and changes in the value of the property and nothing else. That is not the purpose of section 91AD. It's not about periodically adjusting an agreed consideration for the use of land. It's about something completely different. It's about the purchase of the freehold by the tenant with an adjustment made in the tenant's favour, so that to the extent that the price is higher because of improvements that the tenant has made in the past at his own expense, the price will be reduced accordingly. And the rent review cases therefore tell one nothing at all about the correct interpretation of section 91AD. If I could just, while we're in volume 1, look at tab 10, which is another rent review case, which explains again the reason, the rationale for the presumption of reality. case called Chance Button and Compass Services, where Mr. Roger appeared for the successful claimant. And if I could ask the court to turn to page 119 and paragraph 30 in the judgment of Mr. Justice Lawrence Collins. And the key point I get from that is the fourth point that is made by the judge. Presumption of reality is not a mechanistic rule, but really an example of the principle that a commercial approach to construction is the starting point. In other words, you interpret the words in a commercial contract, and a commercial lease is as much a commercial contract as any other commercial contract, by reference to the commercial purpose. And the commercial purpose of a rent review clause is, as we have seen from Basingstoke. So that is the context for the Playdale case, which is in volume 2 at tab 24. There is a serious problem with this case in trying to work out what the facts were. They're nowhere stated. My learned friend has given this court an account of the facts, but it's not an account that I recognise as reflected in anything in the judgment. There are bits and pieces of information that are supplied about what was going on, but no more than that. I don't think time allows me to go through it, but I'd ask the court to read it. Certainly there was land which hadn't been built on, which was called Building J, even though there was no building on it, where the arbitrator determined that it didn't have value for the erection of buildings. There were two buildings called G and H, which the arbitrator valued at site value. Quite what the planning position was in respect to those is not made clear. Clearly, it seems planning permission had been granted for them. When it was granted, when they were erected, is not explained. That's the first point I would make about the case.
So the first point you're making is that the facts are obscure.
The precise planning facts, precisely what was going on in planning terms, is very far from clear from the judgment.
And you would say, as I understand it, well, if there were grants of planning permission which were extant,
there were certainly planning permissions. It may have been that the argument was that the planning permission should be ignored, similar to the argument that was put forward by Mr. Driscoll in Fatal, and that all that Mr. Justice Knox was doing was rejecting that, in which case there's no problem with the case at all. It may be he was deciding something else, but if so, it's very far from clear what he was deciding. He talks about, if one looks at the bottom of page 391, at letter F, he says Mr. Reynolds was suggesting there was a requirement of a disregard of the actual planning permission situation consequent on the existence and occupation of those buildings. Well, that, I'm afraid, doesn't mean anything. Planning permission is a regulatory permission to do things. The existence and occupation of the buildings is a fact, but a planning permission situation...
Sorry, where are you reading from?
I'm so sorry, my lord. It's page 391 at letter F.
Yes, I see.
And then in the next paragraph, about 4 lines up from the bottom, Mr. Justice Knox refers to the shape of the existing planning permission. So there he seems to be talking about the permission. But at the top of the next column, he says the planning situation which their existence had led to. And that's
so
the first...
That phrase on the face of it doesn't help you. That seems adverse to you.
It's difficult to know what it means. Planning situation which their existence had led to. But whatever he decided, the basis on which he decided is apparent from what he said at letters B to D on page 391. He said he was impressed by the basic requirement of rent review clauses. and then he quotes from Basingstoke and Dean. And then below letter D, he says, there's no great difference between the landlord not being allowed to obtain an uncovenanted bonus by charging rent for an activity which he takes care to forbid on the one hand, and a tenant not paying rent for something that he does in fact get on the other. Then he says the Basingstoke case does make clear, if it not before, but similar considerations apply to sites which are to be treated as not having had improvements effected upon them in the shape of buildings as applied to cases where there are buildings which are not to be disregarded. And then he says the formulation seems to me of assistance, and it shows that what a landlord was not to get was a rent additionally inflated by a factor which had no reference either to changes in the value of money or in the value of the site as demised, but which was referable to a factor having no existence as between the actual landlord and the actual tenant, which he gets from Basingstoke. So whatever he decided it by reference to the Basingstoke principle. But the only things you should take into account under a rent review clause are changes in the value of money or changes in the value of the site as demised. Any other factor was to be treated as extraneous. That was the basis of his decision. And that basis has no relevance at all to section 91AD. So whatever he decided, it doesn't assist my learned friend. It's simply irrelevant. But I would submit that if he decided what my learned friend seems to be submitting he decided, then he was wrong. Because what the parties in that case had agreed was that any effect on rent of improvements undertaken by the tenant should be disregarded. And his decision was, as far as one can see in the light of what my learned friend says, is that the tenants were much worse off in terms of the rent because they put the buildings up than they would have been if they hadn't put the buildings up. In my submission, even for rent review purposes, the tenant shouldn't pay a higher rent than he would have to pay if he hadn't erected the building. He increases the value of the property, increases the rent by putting a building up, and it's been agreed that any effect on rent of him putting buildings up shouldn't be taken into account. Well, then it shouldn't be. We have in the bundle two textbooks on rent review that refer to this case.
Yes, do they shed any light on the factual context?
Yes, a little, I would suggest. If I can go to volume 1 and tab 6.
Sorry, tab...
volume 1, tab 6.
6.
This is the handbook of rent review, which is written by Kirk Reynolds, QC, who of course was counsel for the tenant in Railstore, and Guy Featherstone Hall.
Yes. Counsel for the respondent was Mr. David Newberger, Queen's Counsel, as he then was.
Indeed. And on page 81, if the court could read the first paragraph here.
Yeah.
And then he says, then the authors say, in Fatal, a similar point arose in the context of the Leasehold Reform Act. So, given that Mr. Reynolds was in the Railstore case, and given that he seems to have regarded it as deciding no more than you can't disregard the existence of a planning permission, on that basis we have no quarrel with it. The other textbook is Hill and Redman. I think this paragraph may be written by Michael Barnes, QC, but I'm not sure. And it's really just the last 5 lines or so on page 82.
So, yeah.
The editors of Hill and Redman, the last 5 lines or so on page 82, say account may be taken of the existence of an actual planning permission, even though it's been implemented by the tenant, and the resultant development is to be disregarded because it's a tenant's improvement, and the footnote is Railstore and Playdale. What could be relevant in such a case was the value effect of the prospect of implementing the permission. However, planning permissions are subject to time limits for the commencement of a development. It must be established whether the permission has expired. So certainly the editors of Hill and Redman would say, yes, you take into account a planning permission, but you don't take into account the implementation of it, which in our submission is right.
Yes.
So
So just to be clear, suppose the tenant himself had obtained the planning permission, you still take that into account.
Yes.
But if the tenant achieves essentially the same result by doing the work, you don't take it into account.
Well, my lord, you don't take into account any increase in the value of the property which is caused by the works. Causal mechanism is irrelevant. So essentially my answer is yes, except that I would say that the situation that Mr. Scarfe achieved by doing the works in the 70s was not the same as the situation as if he'd got a planning permission. A planning permission is a public document. Any prospective buyer can see it and look at it. If you say, well, I did the works and I got away with it, and the 4-year period has elapsed, that doesn't have the same effect as getting a planning permission. They're different things.
Well, is that tantamount to saying that there would have to be a specific assumption as to established use as opposed to planning permission for that to fall into the same case?
Well, my lord, our case is that you simply assume that the works weren't done, so you don't have to worry about any of these matters.
Yes, but you are differentiating, aren't you, between a planning permission on the one hand and established use gained through the lapse of time
Yes.
on the other.
I am distinguishing, and the reason for the distinction is that in the one case, the obtaining of planning permission, which anybody can apply for, any increase in value is not attributable to any works done to the property at all. There may be no works ever done.
Yes,
It will massively increase the value of the property. In the other case, the value comes from the works.
Here, the grant of planning permission could have been applied for formally by Cadogan, as it could have been by Mr. Scarfe.
Yes.
I mean, either party could have applied for planning permission.
Yes.
And either party, well, Mr. Scarfe could have carried out the works, assuming they were not in breach of the lease, but they wouldn't have been in breach of the lease, presumably, if planning permission had been granted for them. Assume that. Where does all this lead?
Well, my lord, in my submission, it's a false comparison, because for the simple reason that the statute directs attention to increases in value caused by works carried out by the tenant. A planning permission is not, or a listed building consent is not works carried out by the tenant. So,
No.
to that extent, you have regard to reality at the valuation date.
No, I mean, this conduces to the basic argument which you advance, which is that you look at when you consider improvements in that which they necessarily or inevitably entail by way of the planning status of the property.
Well, my lord, no. We don't say, it's my learned friend who says that the planning status needs to be reflected in the valuation. So,
Yes, no, but you're saying that you look at when you're considering improvements, you don't simply stop at the physical works, as I understand your submission.
my submission is that you go back in time to the time when the works were done, and you assume that they had not been done, and the inevitable
and the consequences that go with that.
Yes,
is what I'm getting at.
my lord, yes.
Yeah.
That is our case.
Yeah.
You say the statute says you disregard any value that is a result of, I'm getting this wrong, it says increased by any improvement. So if you find that an improvement has caused an increase in value, you ignore it.
My lord, yes. And the evaluation of the causative effect has been entrusted to the expert tribunal. And there's no limit on the things that can influence value, that carve out the influence of planning and regulatory factors. Well, I know the court wants to finish today. May I just see if I've left anything important out?
Yes. Thank you. Yes, your reply, Mr. Secretary.
Well, given the time, I suspect you've heard enough about this case from both of us. But I do owe you some paragraph numbers.
Well, you're not to think that you have no opportunity to reply if you wish to reply.
No, certainly. I mean, I suspect I would be just repeating myself, but maybe I could
Well, take a moment to reflect and ask yourself whether there's anything you want to submit to us by way of reply. We shall give you that opportunity, of course.
I do not accept. This is ultimately what it comes to. I do not accept the proposition that I am seeking to read in a disregard of planning policies. The essential point is the point I made towards the opening of my submissions, which is that you have to value an unimproved house. There's no direction explicit in the statute as to what exactly the ingredients of that are. And so you have to ascertain them by considering the purpose of the disregard, the consequences of the different competing interpretations. And you have to keep in mind the reality principle and the principle of equivalence. I don't for a moment say that those principles dictate any particular interpretation of the statute. But I do say that the policy of this particular disregard is clearly stated by the House of Lords in Chelsea. And it's to do with the tenant not having to pay twice. And Mr. Jordan's, what I would say, stretching of the disregard, it goes far beyond protecting the tenant from the evil that the assumption was designed to protect him from. And you see that essential point echoing down to cases like Railstore and Playdale, which I don't accept is obscure in what it's saying. When Mr. Justice Knox referred to the expectation of planning permission which ripened into fact so that a building was erected and thereafter the planning law either went through a legislative or policy change at some ex-hypothesi wholly uncertain date in the future, this, as it seems to me, quite fortuitous event should not have the effect of radically altering the rent which it would be proper for the tenant to pay in respect of a totally undisturbed and unaffected occupation pursuant to the lawful planning permission the tenant earlier obtained. What he's saying is there was a planning permission. The buildings were built, and having been built, it was thereafter lawful for the buildings to stay there. It wasn't a breach of planning control for the buildings to be there 20 years later. And so what he's saying is that when you come to the valuation date, which would have been 21 years, I should say, after the date of the grant of the lease, so 21 yearly rent reviews, he's saying it was lawful at that point for these buildings to be there. And therefore you shouldn't value on the basis that it's unlawful for the buildings to be there, because that would radically alter the rent the tenant is required to pay in respect of what is in fact an undisturbed occupation. And that is essentially our point. There is a perfectly lawful, it is perfectly lawful on the valuation date to use an occupied 10 Cheney Walk as a house. That is the reality. Mr. Jordan says, my case is contrary to the reality of the position. It's not at all. The reality is it's perfectly lawful to do that as a result of a long established use. And that is not something that should be wished away under the disregard. neither am I trying to, as Mr. Jordan puts it, resurrect an argument that was rejected in Fatal. The argument in Fatal was completely different. The argument in Fatal was that if you assume the improvements aren't there, then section 91AD is directing you to assume that you can't ever carry them out. Not because you haven't got planning consent. You can't ever carry them out simply because he says the assumption is that the building is not just unimproved, but unimprovable. That is not the argument I'm seeking to resurrect here. Nothing to do with it. The point I'm simply making is about the lawfulness of the use of the building as a house in reality, and that there's nothing in the assumption, section 91AD, that tells you to make any change to that fact. Well, the paragraph numbers the board wanted are, the factors are all a bit jumbled up, if I can put it that way. The relevant paragraph numbers are 19, 25, 26, 37 and 38.
Thank you very much. What remains only is the planning policies.
Yes. We will agree a statement and
Yes.
we'll send it into you.
No, that would be very kind.
With
Can you do that within?
documents that,
Sorry. Can you do that within 7 days?
yes.
Yeah. We just make sure there's nothing else.
No, thank you.
Where should we send it?
Could you send it, please, to my clerk, Anna Cullen, whose email address I think for those instructions you should have, or your clerks will have.
We shall do that.
Yes. Thank you very much. Well, it follows from what has just been exchanged between us that we shall not give judgment straight away. We're going to reserve our judgments, give them in due course. Before they are handed down, a draft of them will be circulated in the usual way for any minor typographical or factual errors to be corrected, not in any way to traverse the court's reasoning. An order should be agreed before hand down, and any consequential submissions tendered to the court, please, at the same time. Those arrangements are, of course, entirely normal arrangements for hand down. Thank you both very much, and those who have assisted you. You're very clear, both written and oral arguments. We are grateful to you. Thank you.
All rise.